of research. Its issues of inquiry naturally relate to pure law or law in relation to society. Anyone engaged in research pertaining to law is a legal researcher. But as an occupational exercise, legal research is needed for judges, lawyers, and law academicians. The functional structure of modern judicial system permits little scope for research at the trial court. Whatever research is possible is actually done by appellate court judges. Many lawyers do conduct legal research, but it depends upon the caliber of the lawyer and nature of the case. Judges and lawyers do possess an excellent caliber for research. Whenever they come across an issue with interpretative inquiry, they do the job diligently and add to the legal knowledge by their brilliant exposition. In the process of logical elimination is applied, it can be said that the legal research to some extent has become exclusive responsibility of academicians. Secondly, the academic institutions have to accept greater responsibility for legal research because in a globalized world, the role of research is significant for their sustainability and development. There is a close relationship between teaching and research. A law academician in India is expected to teach as well as to contribute to the legal research. Whether he is adequately equipped to perform the dual role or actually performing his role satisfactorily is a matter of inquiry. The lack of adequate financial support is a great concern uh, for legal research and legal writings. The ethical issues related to conduct of legal research has even raised the concern of policymakers. These are some of the few casual features emerging from within the system that are responsible for unenviable state of legal research in our country. Most of law academicians have agreed that much needs to be done about the quality and model of legal research in India. With these challenges and concerns visible at horizon, the choice of the topic legal research in India, current trends and challenges has great significance and relevance. At this juncture, with these objectives in mind, we are fortunate enough to have with us respected Professor S.C. Raina sir and respected Professor P.K. Malhotra sir, who have accepted our invitation in spite of their preoccupations. On behalf of School of Law, Sharda University, I express my gratitude to Professor S.C. Raina sir and respected Professor P.K. Malhotra sir and wish all participants a very fruitful discussion. Now, I would like to invite respected Dean sir to share his views. Please, sir.
Thank you, Dr. Rohan Cole, for very good opening remarks. It is my proud privilege to welcome Professor S.C. Raina. He is presently Director, KIIT Law Institute, and he has been founder, Vice Chancellor of Shimla. And before that, he was Dean Faculty of Law, Delhi University. And he has contributed in a big way to the cause of legal education in India. And we all know him well, and he doesn't need elaborate introduction. We all have been benefited by his benevolent guidance in some part of our life. He has authored several research publications, and thank you very much, sir, for sparing a valuable time
Thank you.
and gracing this webinar. We also have with us Mr. P.K. Malhotra. He is former Law Secretary, Ministry of Law and Justice. He is at present Distinguished Professor in the School of Law, and he has been contributing in a big way in the growth of the School of Law. He has more than 40 years of rich experience in the field of law. Of that, 25 years as officer of the Indian Legal Service, and he has been heading many committees, many amendment to the constitution like NJAC was part of it. Uh, Today's topic is very relevant because, as we all know, that research is very essential, and somehow most of us are very content teaching only our subjects, but that is half job done. because until we do research, our quality of teaching will never improve. And legal research primarily is gathering of evidence or information or ascertaining an assumption or verifying some hypothesis. Research is therefore an inquiry for the verification of a fresh theory or for supplementing prevailing theories by new knowledge. No research can be purely new, as even original discoveries are an extension of search already undertaken, being shaped generally as expressing agreement or refuting or plain addition. We have with us Professor Raina. He is an authority on the subject, and he shall be telling about legal research, how to go about this in detail. With these words, I, on my own behalf and on behalf of the management, faculty, non-teaching staff, students, participants, extend a very warm welcome to Professor S. C. Raina. And once again, I thank him very much. Thank you very much.
Okay, sir. Thank you, sir. Now I would like to invite respected Professor P.K. Malhotra, sir, to share his views. Please, sir.
Well, star speaker of the day, Dr. Raina, Director, KIIT University, School of Law, KIIT University, Professor Pradeep Kulsresht, Mr. Rohit Kaul, Assistant Professor, School of Law, other distinguished participants in this webinar, a very warm welcome and good morning to all of you. I think the seminars, the webinars which School of Law, Sharda University is conducting, that right from the time the lockdown was declared, I think we have already, Professor Pradeep conducted how many? 20 webinars in the range of about 20 webinars, and to disseminate knowledge and to share knowledge and to bring people who have really done some good job on the subject and permit them to interact with the students and encourage the students to ask them questions so that they can get benefit of their experience which they have acquired in the field of law. I think today's topic, that is legal research, becomes very, very important for all of us who are participating here, because based on my own experience, I feel this is one area probably there is a lot of scope for doing a lot of work, because this area has main whatever research, legal research has been done, either it is because of the individual efforts of the judges or the lawyers who are contributing to the system. And so far as the institutional level is concerned, barring a few universities and the national law schools which have been constituted by the various states, barring them, the research in most of the areas have remained neglected. Take, for example, I'm just giving an illustration because I've handled this matter when I was law secretary and also ex officio member of the Law Commission of India. This research on death penalty, a lot of research has been done, but the way it be collated and presented before the participants, before the students who are interested in this particular subject is not available. Very recently, I came across about a recent study which has been done by the National Law University at Delhi. And so the point which I'm trying to make here is, probably all this job is being done in certain compartments, in watertight compartments. And probably the benefit of this is not available to the people who should actually get its benefit, so that further development in the law can take place uniformly. I'm again reminded of, and I would like to share with all the participants here, all of you may be knowing about the Indian Law Institute, which was the dream project constituted by Pandit Jawaharlal Nehru. And the main idea of constituting this Indian Law Institute was that it will be analyzing the Supreme Court judgments, doing some other research activity, and enlightening the legal fraternity as well as the nation with regard to the national as well as international practices as to where we stand and what are the areas where there are weaknesses and progress need to be done. Unfortunately, it has not come to that level, although it is coming out with periodicals, it is coming out with journal. At the initial years, that kind of research was done, but now it has become a deemed university imparting education in LLM or giving some diploma courses. I think it was not meant for it. It is meant for a much bigger job because it is supported by the government. But probably, I mean, the time has come when probably those who are at the affair at the Indian law see that the objective for which the Indian Law Institute was constituted, probably it is discharging its duties in the same fashion. The kind of contribution we are looking in the legal research is coming forward from that institute. I remember about a decade back, efforts were made to ensure that, and at the law ministry level also, consultation paper was also circulated. Let us have 4 regional institutes at the regional level for research and higher education. But unfortunately, that proposal also couldn't see light of the day because of certain issues which were raised either by the Planning Commission or the kind of finances which were required for these regional centers to make these, to establish these institutes. This not having happened at the government level, I think the schools of law which are functioning in the universities, probably their responsibility has increased. The kind of people we have who are manning these institutes, be they the national schools or the universities like KIIT University, where Professor Raina is there, or the Sharda University, where Professor Pradeep Kulshrestha is there. Similar other universities are also there. As I mentioned, that some research being done by the special seat constituted by various universities. They can pick up the responsibility so that the kind of development which we are expecting in the field of law, that can be projected and placed before the government for legal reforms, whatever are needed. Now, I think I won't take much time in the this particular aspect because all of us, all the participants, including myself, we are more keen on hearing the views on this particular subject from Professor Raina, who is the star speaker for the day. Thank you very much.
Thank you very much, sir.
Thank you, sir. Now I would like to invite esteemed Professor S.C. Raina, sir, to enlighten us with his views. Please, sir.
Thank you. Good morning to all of you. Mr. Dean of the Sharda University, a close friend of mine. Respected Professor Malhotra, now he's a professor now. Earlier the bureaucrat. Both ways good and both ways contributing to the legal profession. Young friends who are the faculty there at the Sharda and all participants who are the participants for this webinar. It is from seminar to webinar. This is transfer of technology. Friends, I think Professor Malhotra has laid down a very good prospects of the legal research in India, except that he has restrained himself from saying certain things about the pioneer legal institutes which we try to make and which are in shambles these days. Anyway, that's not the point. Point is that researches in law have been as a process, whether since the Supreme Court came into existence or the High Courts came into existence, that we tried to make more researches in law on certain basic phrases or certain basic, what we say, maxims. Laid down doctrines were being analyzed and analyzed to the extent by virtue of the case law decided by the High Court, on the basis of the case law decided by the Supreme Court, or at that time Privy Council and House of Lords and all that, because America was being transferred much into the judgments of Supreme Court as late as 90s. It's now after 90s that we quote less from America or from other places. Now, what was being done in that legal research was that a phraseology or say legal maxim was being actually tried to be interpreted, say 4 cases have said like this and then 4 more cases have said like this. and the analysis was, it was, I think, so far as my knowledge goes, or I have an experience of this thing, it was nothing except the documentation, which perhaps was haphazard, and we used to compile it in a very beautiful way. The way we used to compile was the type of the research we used to do. Good research, very good research, the best research. These were titles given to the way you can compile or you can weave a carpet. If you place good colors in a carpet, it was very good. If you cannot keep good colors in a carpet, it was not so good. But ultimately, it was decided by the courts, and we were interpreting the same thing what the courts have done and analyzing that in 10 cases this has been done. And friends, our contribution was 4 lines. Please read, I will repeat the 4 lines, and I hope you will keep your hand on your heart and say, am I right or not? After 10 cases, we used to say, from the above cases cited, we come to the conclusion, whatever the conclusion was. For example, as Professor Malhotra says, that death penalty is a need for retention in India. This was the conclusion, full stop. This was contribution of ours. Then another 10 cases, another 4 lines of the same nature. You'll find this trend was almost available till as late as 80s. That's why you'll find that most of the researches in law in India, I'm talking of India, were being either in constitutional law or in administrative law. Go and check the libraries. You can find it, it was not from any other law. Now these intellectual property, other laws and other things have come up now, not that they were not in existence. Copyright was there, but no research was there. In arbitration, mediation, reconciliation, whatever you call, no research was there. Even in contract law, you will find very few researches. I don't find anyone. Now, reason for this was that it was a constitutional law is still evolving at that point of time when we were completely independent achieved, that it was much more evolving. Every day, every year, we had new cases, new interpretation, as was in case of administrative. Now, that era is gone. Not that it is not essential, it is essential, but that era is gone. Because law now is a full-fledged social science. Because the moment you create a law, it has an impact on society. The latest example is that all of you must be knowing that we are locked down under a certain particular law. Do you know which law we are under lockdown? Is it IPC?
Disaster Management Act.
Disaster Management Act.
Huh? Exactly.
Disaster Management.
It's Disaster Management Act, which speaks of lockdown in the areas where there is a disaster. Our management is not correct to retain the disaster. So we can't violate it. There are specific sections which say so. Hence, what I'm saying is that the moment you impose a law or you create a law, it has a direct impact on society. Partly or fully or whatever. For example, Act reserved for the reservation, even in the constitutional mandate. We say reservation for certain classes or certain castes. It has an impact on that caste or that class. If we assess it, we want to assess it, has that law really yielded the result? How should we do it? Supreme Court judgments 20, 30, 40 on caste-based reservation and other reservations will lead us from Balaji to anything. Last perhaps Balaji or some law related to the establishment of the educational institutions. 30 cases decided, Supreme Court says, yes, reservation should have. I'm not concerned with that. My research is, has this reservation really percolated down to the society, and has that particular person who really deserves reservation, has he got it? Or has it remained only on the papers and only after the Meera Kumar the reservations have happened? That means have the people who are in the same caste but still are in the higher ups, they have actually reaped the crop of this reservation. Who will tell me? How should I do it? Judgments will not say me anything. Judgments will say that whether 50% is correct or above 50% is incorrect. Whether reservation on religion basis are correct or are not correct. Economic basis are correct or not correct. So judgment only speaks of correctness and incorrectness of the law which you say. But has that actually reached? For example, I say about the lockdown. If I say lockdown, I want to assess as to how many persons in a particular locality in Delhi have violated this lockdown. And if they have violated, what is the law which has been imposed on them, either in the form of punitive process or in the form of preventive process? Now, nobody will say me. The police people may not be knowing even themselves. They must be arresting people, perhaps arresting them. And therefore, that pen and paper law or the armchair law, which I used to do on constitutional law or some other law, taking books together, piling them on both sides of my table, and writing a good thesis, that era is gone. That's the first challenge to the legal research in India. That now, that old and what we call, or you must have been taught by the teacher, what we call as doctrinal research, is the least in action now. It is an action. I don't reject it. It is necessary. It is mandatory. It is a supplement to the non-doctrinal law. But it is not the basic now. So the basic which has taken turns is that the non-doctrinal law. What it is that is the phrase that if you want to see the depth of the sea, you will have actually to wet your shoes. Unless you go deep into the sea, how can you see the depth of sea? Therefore, in order to have a legal research, you will have to go to the society and say, has it happened or has it not happened? Has sanitization happened in a particular mohalla or a particular locality? Sitting at a place and just reading newspaper and quoting from them, yes, 5% sanitization has taken place, 95% has not taken place. COVID is at this process, COVID is not that process. Is nothing but copying from one piece, compiling it in a beautiful way. It depends upon your vocabulary and the method of compiling that you say is the research. But if we want really to say, yes, it has affected, sanitization has taken place for more than 95% of the population in Delhi, then I will have to visit the localities, ask the people, has it taken place? What do we mean by that sanitization? Does it mean water sprinkling? Does it mean some chemical sprinkling? People should know about it. Therefore, the turn is now of the non-doctrinal research. That means you will have to say, yes, it is a law, it is meant for society. Therefore, the society will respond as to whether the law is good or law is bad. Or if it is good, we mean it, we should make it better. Or if it is bad, we should take it away. So the amendments, ratifications, certain other processes will not come from me as a simple person, will come from the data which is the primary source of the society. So the society will respond to. Society's response will be the response to my legal process. And that's why the law which I will frame will be exactly what Dicey says is the law based on public opinion. If I make a law which is not based on public opinion, perhaps the law will crumble at any place of time. You'll find it. That's why the empirical research is a new dimension of research. I will not take much time for this. Now, once we do empirical research or any research, friends, research is not something, I will make it clear as a covert or a footnote. Research is not something which you do as a novel thing. It's not an patenting anything. It's not invention, nor is it a discovery. Invention is something new where patenting is possible. Discovery is something where it is undiscovered and you remove the cover. It is existing, but you simply remove the cover as Vasco da Gama did with respect to India. Research is to search for something which has already been searched. That's why in a rhetoric system we say it's an addition to the already existing knowledge. There is a knowledge. Malhotra Sahib has written a good number of books. Suppose I want to do research on the same area. What should be my contribution is an addition to that what Professor Malhotra has already said. And that additional part is my research. Otherwise, the research relating to drafting are enough. Therefore, Malhotra Sahib has already published. Or research relating to family law. or IPR or anything exists there. But what is my research is re and search. Something which has been searched, I am researching it again. It's an unending process, friends. Why is it an unending process? Because the topic you choose for a research, I'm talking of legal topic. Legal topic you choose for a research, you can't complete it perfectly. So there are exactly gaps existing in your research which the other person exploits for his research. The gaps are that either you leave the gaps deliberately or the gaps are left inadvertently. Deliberately means we say the scope of my research. The scope means my research has only these things. 1, 2, 3, 4, 5. So I will not go to 6, 7, 8, 9. So I am deliberately confining my research to a particular circumference. I am perfect because I don't have time to do all 10 points. I am taking only 3 points, 4 points, or 5 points. So I am deliberately leaving the 5th, 6th, 7th, 8th. Or while carrying on research on a topic, I may feel short of time or I may miss certain things. Whatever the reason may be, this is inadvertent. So in both ways, whether you do it deliberately or you do it inadvertently, there are gaps in your research. Now these gaps are the gaps which some new researcher takes up and completes that gap. This is what is called as review of literature. You are reviewing the literature of A, B, C, D, and then say, yes, sir, they have done this much, but they have not touched this aspect. That aspect which they have not touched is the new aspect or the new area where you take up your research. And when, friends, you are doing your research, you will also do the same process. You will also leave certain gaps, because perfectness can never happen. I have always been saying that a research is perfect which has its imperfectness, or the imperfectness is the soul of a perfect research. थोड़ी imperfectness होनी चाहिए, तभी the research बढ़िया होगा. अगर सारा हम बोले हैं perfect है, then it's not a research. It is something which has been copied. That's why we say plagiarism and other things जो अब नए चीज़ आए. But once you choose the topic, there are 2-3 things in choosing the topic. Topic choice is really a great choice. I think half of the research is done if the topic chosen is correct. I'm sure you will agree with me, friends. Have you done all of your dissertations or PhDs? No, you are in LLM. Now, the dissertations you must be writing or you must have written it. How have you chosen your topic? I'll not take time. I'll say it myself because we are not face to face in the sense. Now, topic is chosen in different ways. The best method of choosing the topic is you understand the area you want to do. Say you want to do in the IPR area. And out of the IPR, you want to do on geographical indications. Therefore, you will read as to what IPR is, and out of IPR, then you will go to the geographical indication, which is now the latest part of IPR, and we'll see as to how many people have done it. And if they have done it, then you will add as to what you will do. Now, once you choose the topic, then you put the title of the topic. So choice of the topic and the title of the topic is very important. I will say what mistakes we do, friends. We choose the topic which is vague. And we put the title of the topic. And we put the title of the topic in a sense as if it is conclusion. For example, I say death penalty resolves many criminal problems in India. Is it a topic or a conclusion? It's a conclusion. Because I feel it's my conclusion. I presume, yes, this happens. Then I try to find out in my thesis, I try to make out in my thesis, yes, this exactly has happened. Had it not been so, then Ranga and Bila would have not been killed. Has it not been so, then what happened in Nirbhai's case would have not happened. So I'm actually justifying the topic or the conclusion which I have placed. That's not research. Research is unearthing certain things. a presumption, right? A presumption which you make just, and that presumption should either turn to be true or turn to be untrue, or it can be half true and half untrue. So that's not you in your hands. ये वैसा ही चीज है जैसे कर्म करो फल की इच्छा न रखो. So you have to do it, and whatever will be the results, you have to face them. And once you face those results, that is your research. This is one thing. Second, when we choose the topic, we don't choose it ourselves. We don't go for review. We don't want to waste time in library. We do not know what the library is. I think most of us have never visited library. I also done the same. I hope you must also be doing the same. And what we do is we take a mouse in our hand and just push it as many times as we can, cut and paste and say, sir, मैं इस पर research कर लूँ. And supervisors like me also wave their hands at half a kilometer distance. Ha, बहुत अच्छा topic. Ultimately, what happens is that either the supervisor leaves or the student leaves the topic in between. The second method of choosing the topic is, which is common, that you find on newspapers, which should be, you find on newspapers or you find on certain issues historical, that these are the various issues which the society is facing. Therefore, you want to find the solution to this. For example, abhi jo hua hai, that is our industry completely dependent on those whom we call now as urban poor or migrant laborers. It's a hypothesis. If it is proved, then it means that Bombay is not Bombay. Bombay is partly Bihar and UP. Right, friends? This is something which historically we have to say and then to prove it. The third and the most important thing when we do research, particularly when we are in LLM or PhD, is then we hang after a teacher. हम पीछे पीछे चलते हैं टीचर के. And then hand folded कहते हैं सर माई बाप हैं टॉपिक तो बता दो. And this is common. I hope you will agree. Or we ask some researcher, senior one, he says the topic. Don't do, these are dangerous exercises. Topic should either be chosen out of the review or topic should either be chosen out of the facts which are existing in society and then to find out the solution which exists. In such a selection which is correct, then you have not to face the problems time and again. It's a thread which will go on. If you choose the topic in other way, then at every point of time, you will have to meet your supervisor. Friends, this is nothing but an exhibition of the, it is a projection of the supervisor himself. Projection means, suppose I want to be a doctor, I couldn't be. Then what I do? I have that feeling in my mind that I couldn't make it for my MBBS. Therefore, I push my son, who is too young. Well, you should get 99%. You should get 200%. I don't know where from. But I pressurize him and somehow I put him to the course for MBBS. He fails, miserably fails. MBBS is for 5 years, he does it in 12 years. This is projection. Basically, I want to actually give vent to my feeling. Therefore, if the supervisor says the topic, it is his topic, it is not your topic. He has actually in his mind something which he could not do when he was doing research, or he has no time to do it. Therefore, he thrusts on you. Topic is your choice. And the topic is not necessarily, it should be a big bombastic topic. Topic should be very fine. And as much time as you apply to the choice of the topic and choice of the title, your research is done. It will not take much time because you are on the right track. Then you have the choice of, actually, that's why I'm saying these choices are basically challenges. In the doctrinal research, we don't choose much about it. Ab dekhiye, doctrinal research, whatever we have done, will be almost in multiples of the same areas or multiples of the same topics. In empirical, you have your own choice. You have your own conclusions. You have different conclusions even if the topics seem to be same. For example, I do a topic on dowry deaths. And if I apply the same topic in Maharashtra and apply the same topic in Odisha, I apply the same topic in, when I apply means the same topic is being researched in Delhi, in Odisha, in Maharashtra, or in some other place, say Kolkata. Do you think that the conclusions will be same? Findings will be same? Even though the sample must be of similar size. We take 100 people at every point of time, and we interview them in the same interview schedule. I'm sure the conclusion will be different because the set of the society will be quite different. Wherever you will find cohesion of society, Bengal में Bengali culture है. If the culture is dominant, the results will be different in such cases which are completely socially based cases. If the culture is fragmented as is in Delhi, we don't have a culture in the sense, we don't have one community culture in Delhi. It's completely a real cosmopolitan. Everybody lives in Delhi. Therefore, everybody's culture is in Delhi. And hence the conclusion related to this topic in Delhi will be quite different than in case of Maharashtra. Maharashtra, mein, there's a strong Marathi culture. That's the reason that even if you have the same topic or a similar topic, but if you apply it in a different phases or different ways, your conclusion will be different. Hence, you are the master of your topic yourself. Nobody can say, no, your topic is wrong because I did it in Delhi. It was quite different. And you did it in Maharashtra, it doesn't meet any point of time. Whereas the judgment which has been made by the High Court or Supreme Court or whatever has been said in the books related to a particular phrase of law or particular problem of law should be the same result, right? And that's why the point is quite different. But what is important is choice of topic, I said, then you have to go for a methodology which is correct methodology. Methodology is different than methods. Method means the type of the research you want to choose. You can have a descriptive research, you can have a corroborative research, you can have collaborative research, right? I hope I need not to explain each one of research, but there is a little difference between a descriptive research and rest of the empirical research. In descriptive researches, what you actually do is you are actually trying to describe as to how has it happened, why has it happened. Therefore, you do not to develop hypotheses in that. This is underline what I am saying. In descriptive researches, you need not to develop hypotheses. You only had the research questions. In rest of the researches, whether it is corroborative, whether it is collaborative, whether it is otherwise, then you have to develop the hypothesis. And I hope hypothesis means you presume 3-4 things, where there's a correlation between the two different things. For example, friends, I say a person who eats 40 grams of protein extra raises his length by an inch every year. So I'm trying to make a relationship between eating of protein and raising of height. I interview at least say 200 people whom I keep under control for 2 years and then measure their height at intervals. Say after every 20 days or 1 month, I measure their height. I induct them 40 grams of protein every day. If what I presume that yes, it increases, then after 2 years, my result should be yes. That means intake of protein raises the height. Or there's a direct relationship between intake of protein and the height gain. If it is proved by those 200 means majority. I don't say exactly 200. If it is 180, 190, 170, so majority of the people say it is proved. But if the majority of the people are against it, they say, nothing has happened. My protein kitna bhi khao, my height has not improved, right? Then it is not a correct hypothesis. But that does not mean it's not a correct research. That's the point. Hypothesis never makes a research correct or incorrect. Hypotheses are only that I presume that this could happen, but if it is not proved, not by me, but by the society, but by those people who are there. For example, I will give the latest. We are trying to develop vaccine this time for the COVID-19, right? People say plasma therapy is good. People say, no, the drug which is for the malaria is equally good. People say the drug which the Americans have said is good. These are all presumptions, friends. Now, in order to prove this presumption, for example, I test 200 patients in Gangara, I test 100 patients in All India Medical Institute, and I test 100 patients in Vedanta. And all to these 300 patients differently, I use drugs for 100 patients as that of malaria, for 100 patients plasma, and for 100 patients the third drug. The result will tell me after 10 days as to which drug has actually successfully made its way over the COVID. If it is plasma therapy, I will immediately come out with the conclusion, yes, plasma therapy is a successful alternative till the vaccine is produced to save people or to prevent this. But if all the three are good, all the three can be there. That is what the empirical research actually makes us to do. It's not based on something which some judge has said. I may be a judge, I'm whimsical at times, I'm sorry, with due respects to, they are supreme because they are next to God always. And so, because Supreme Court is not a supreme place. So Supreme Court.
It is supreme.
Sir?
It is supreme.
Anyway, whatever they say, we have to agree to that. We can't disagree because Article 141 or 142 says, is the law of the land, they say, that the brother can kill brother is the law of the land.
Yes.
No problem. We have to agree to that. We can't say no. It's a resurrection hai. Anyway, but in empirical research, there's nothing as agreeing or disagreeing. You may agree with the conclusions, that's your choice. But if the conclusions say your presumption is wrong, you have to agree to that my presumption is wrong. It is as good as Professor Malhotra will agree with me and even Professor Shah, that it is evidence. If the evidence is capable of proving, it is proved. If it is not capable of proving, we say it's not proved, it is disproved. So there is no choice, either proved or disproved. In between, there is no choice. In the doctrinal research, there is a choice in between. Once there is a choice in between, the process of manipulation takes place more. And where there is least choice, the process of manipulation doesn't take place. Once you do that part of research, that's very important. I'll skip a bit of it. What comes is analysis and interpretation. I hope you place the tables and then analyze them in a very beautiful way. The analysis of a table is nothing but the analysis of the data you have actually placed. Hopefully all of you know because you are a techno-savvy, that in the computer we do not put the words, we play the numericals. So every question is placed in the form of a numerical. That's why in a questionnaire we place the number as 1, 1.1, 1.2, 1.3, 1.4. That means it is basically question number 1, then part 1, part 2, part 3, and part 4. Once we reconvert them back after the data, we are basically analyzing it back. Then we give the meaning. जैसे coding करते हैं, इसी तरह 1.1, 1.1, 1.2 coding. And when we decode them, we say yes. Question number 1 means, are you agreeing to this or don't you agree to this? The responses we get, we actually apply. We then say 70% of the people agree, 20 people disagree, 10% could not speak anything. That's how we analyze it. This is analysis. It is very easy. Anybody can make the data, put it into tables, and analyze it. I'm not saying it is easy in the sense that it is easy for you. It is, you learn it and you can do it. But what is important is that after the table is analyzed, you will have to say what's the outcome of table. Those who are from basic science subjects can perhaps understand me a bit quicker. Once you do a salt analysis, I hope you must have done, most of you. Salt analysis is, suppose sodium chloride, khane ka namak, is given to you on your hand. Now chemically it is said it is a part of sodium as a part of chloride. How will you say it is sodium and chloride? It's not by test. It's not by taste. Taste you can do it, there's a different method which we can cheat. Otherwise what we do is, that we put the sodium chloride into a test tube and put some acid into it, particularly HCl, hydrochloric acid. It gives different fumes, which are the fumes of chloride. In a room where the fumes of chloride exist, you can't stay. It causes suffocation. And then you test another part of it. Once both tests say positive to you, that you say, yes, it is sodium chloride, because one part is sodium, the other part is chloride. Similarly, once you make a table and interpret it or analyze it, then you have to infer. That's the part of inference. 3-4 lines of inferences are there. Inference means as to what have you drawn out of. As friends, every evidence is an inference. It's not a conclusion. In order to be on a safer side in empirical research, we make inference of every table. We say probably, not possibly. Probably as to what we have done and the data we shows means 80% agree, yes, COVID can be controlled. 20% agree, yes, it cannot be controlled. But an empirical research will say us, is it there or is it not there? It's or research. Suppose I gave the example of this caste reservation. We do it and the table says, yes, in UP, it has reached to the last rank of the reserved category, but in Bihar, it has not reached. In Nagaland, it has not reached. Then what can be the inference? Inference means, I'll make it way, make it different. I'm not blaming it you. I'm not saying that it is, because I know a bit ABC better than you. I will make an inference that a state which is much closer to the center, or a state which is much closer to Supreme Court, right, performs better in relating to reservation. A state which is almost in Arunachal Pradesh is too far from Supreme Court. That means center, the peripheral states apply the law in a peripheral way. And the moment we concentrate towards the center, the states apply the law in a better way. This is my inference. And my inference is not final. Once I make this inference, then here comes the doctrinal research, which I said is very important. Somebody else must have done it earlier, 10 years, 5 years, 2 years, whatever the method is. Then I am quoting him from secondary sources that my conclusion or my inference is being supported by this in 1990 are done by Professor sometimes, are done by Mr. Cole in such and such times, or done by any one of you 4 or 5 years. I'm actually strengthening my conclusion. Once I get 10 such conclusions which actually result in the positiveness of my topic, then I say my topic or my hypothesis are perfect. Each hypothesis is to be tested by virtue of the tables you have actually collected. And the last part before I say goodbye to all of you. Last part is the footnoting. It's miserable, friends. In the legal research, it is miserable. And we are, I don't, instead of being better, we are going towards the worst. I don't know why. The fault lies with us. The fault doesn't lie with you as students. The fault lies with me as a teacher. Perhaps I am not teaching perfectly well. Either I do not know, I do not want to, or I do not want to give time. People who say, yes, I will teach research methodology, should be first taken interview with respect to footnoting. The footnoting, friends, should be, I don't say it should be something which is from Oxford or from Harvard or from, though we have the Harvard Blue Book, but the question is, whatever the method of footnoting you apply, it should be uniform. It can't be for chapter 1 different and for chapter 2 different. It should be uniform. You give one method, say the method which ILI has applied. The ILI has not any standard. But even if we say, I agree, even if we say I have applied what the ILI has been doing in its publication, then that should be for chapter 1, chapter 2, chapter whatever chapters. It should be number. And now we have a method, whether you go for footnoting or you go for endnoting. But the method should be the same. Footnoting is basically a British style and endnoting is an American style. If asked to me, I will say footnoting is far better than endnoting. Footnoting means whatever you read at the top, at the bottom, the source is given. Endnoting is turning pages and saying at the end, something like that. And second thing is that from I think 85 onwards, what has become important is that we place the source of the footnoting too. Suppose it's a book written by Professor Malhotra, we say such and such, name of the author, name of the book, then the publisher is to be given now. This publication earlier perhaps we used to avoid because it was not a global world. Sorry, it was not a uniform world. Now we are globalized and uniform. Now whatever you write here within 10 minutes through your internet, it will be available in any university of America. That's why the publication is to be given, whether it's being published by the Eastern Book Company or the Halsbury Laws of England, or is being published by anybody else. That is very important. Pages and other things are equally important, right? I hope you know that there is a priority in footnoting. The book is to be written first, the articles, the research papers, the second. This is a priority. It doesn't happen. As it's a priority in case of winding up, as to who gets the mall after the winding up. And similarly, books are to be written first in priority. Then articles or research papers second. Then third are the official reports. Say Government of India, Law Commission of India, right? And then unofficial reports. Any NGO which has done any work, for example, death penalty done by the National Law University of Delhi, right, can be an unofficial report relating to death penalty. So official reporting, then unofficial reporting, then newspaper cuttings, and then, which is very quick and best to use, websites. But websites with dates have to be given because they are not permanent. You will have to write visited on such and such date and such place. These are the challenges basically, whether you know footnoting, whether you know the writing skills, whether you know the hypothesis developing. I think I congratulate Mr. Kulshrestha for holding such seminars, and I think I do not know the teachers who are teaching you, but I'm sure that they must be teaching you well because Kulshrestha is a very good hard taskmaster. And but I think regularly these things should happen, and practically they need to be demonstrated. And the times go better, it need to be demonstrated at the university level, and these are the things which have to happen. I'm open to questions because I want to learn from you as to what are my mistakes. Welcome, friends.
Okay, sir. Thank you very much. Sir, we have a question from
Please.
Formar. So the question is regarding to empirical research, and he wants to know the factors which we should keep in mind while selecting a sample. The factors we have to keep in mind while we select a sample, and he is particular about selecting of sample with respect to two different companies.
It's not audible. I think factors which need to be kept in mind for what?
For
Sampling.
selecting a sample. For
Factors
selecting a sample. Factors which we should keep in mind while selecting a sample. With respect to empirical research.
Okay, no problem. Can't be uniform. Sorry, sample cannot be uniform for every type of research. It's the research which should itself say as to which sampling I should go for. Normally, we go for one method of sampling, say simple and but at times it will be necessary to go for two types of sampling. We can have sampling at different stages, multi-layer sampling or multi-stage sampling. So the topic will define combination of two things together. For example, topic on law and economics, the sampling can be different. You will have to have multiple sampling or a multiple stage sampling. In each stage पर एक sampling, फिर जब second stage आता है दूसरी sampling. So topic निकाल के लगा दिया. It's not a ready-made tool.
I think there is some problem in the connectivity.
Yeah.
Dr. Rohin, you may request sir to stop
और
the
बताइए.
video. Then audio will.
Okay, sir.
Next question, ready.
Sir, I have a question. Sir, am I audible? Okay, sir. Sir, I have a question as a law teacher. Sir, as a law teacher, I have a question with respect to projects. Writing a research article is a different, writing a book is a different, but with respect to
Project
yes, sir. With respect to projects, sir, as you have done, you have conducted a very magnificent project. Sir, as a law teacher, we are curious with respect to the factors which we should keep while going for a law project. Sir, I
one is where you
Raina, sir, I request you to just mute your video. Sir, I request you to just mute your video so that we can easily, there is some network issue, so we can easily hear you.
Hello.
Yes.
Yes, sir.
Yes, sir.
Now
Hello.
it's clear.
Yes, sir.
I was saying that projects are basically sponsored researches. But sponsored researches can also be, projects can be of two types. One is where you yourself suggest a project. For example, ICSR, you can apply for a project on any topic you like, which is has a social basis. Any topic you like. That's project given by you. Therefore, has 2-3 dimensions which are yours. One is time limit, money limit, and other things. That's your project. Other are sponsored, tailored projects. For example, Human Rights Commission, Bureau of Police Research and Investigation, Commission for Women as such. All these are actually sponsored projects. They advertise every year 10-20 projects and ask people who can write on that. Now they are limited in time. The caption is given by them, heading is given by them, the time is given by them, and the budget also is given by them. So you have to fix yourself or customize yourself to that project. In the project which you give, you have not to customize, except as per their requirement. They may trim certain things, but then your time and money is yours. You may ask 20 lakhs to them, they may agree to 15 lakhs. You may ask 2 years, they may say no, 2 months less than 2 years. But in those which are project sponsored, there the time limit is fixed. For example, I did my last project on Human Rights Commission, which was a project of a year, 1 year only. The money was almost 16 lakhs and something. I did it. I have submitted. I got the money also. I'm a rich man these days. You don't get money from projects, please. There's no richness. That's what I want to clear. You are an investigator. You do the job of an investigation. But what is important is my 1 year was fixed. I can't change it. Except that by virtue of request, I can say extend it by 1 month more because my job is not yet complete. But if you give project yourself and say I can do it 3 years, and if they agree, then it's your project. That's
There seems to be some connectivity issue. Not
Yes, sir,
audible.
issues.
Not audible.
Yes,
Yeah.
right, sir.
one is that it becomes a wonderful dish. और बताइए सर.
Paul, you can go for the next question.
Okay, sir. Sir, and there is a continuous queries everybody asks. This is a question regarding plagiarism, and it's from a student. He wants to know how to reduce this plagiarism.
Should I share the trick or should I say the reality? सच बोलना चाहिए या कोई जादू बता दूं या सच बोल?
दोनों सर.
So as you wish.
Now I think the UGC has started a paper of 2 credits more on plagiarism and other things. वो सब employment opportunity के लिए है, nothing is. My dear friend, one should be honest that whatever you pick up. Is Cole asking me the question?
Yes, sir. Yes, sir.
You are a teacher from IPR. You should know that I should in no case violate the Copyright Act.
Right, sir.
The best method not to violate Copyright Act is I should give the footnote at the end and say, thank you, Mr. X. I have copied from your law and I am very thankful to you. Once you give thanks in the footnote, that means once you quote the footnote, then there is no plagiarism. हमें क्या है? We feel shy in giving as many footnotes as we can. हमें लगता है कि अगर हमने एक लाइन में 3 footnote दिए, लोग ये सोचे कि इसने नकल किया है. We are not thinking that if we give 3 footnotes in 1 line, it means we have actually analyzed that line to the extent that it was very important line.
Right.
And why should we feel shy? If it is written by Robin Cole, I should say, yes, Robin Cole, such and such page, such and such. That's the real method, which we do not do. और अपने सुपरवाइजर भी ये कहते हैं, अरे कम करो यार, ये देखो सिर्फ जिन टीचर्स के पास जाती उनके नाम होने चाहिए, जो उनके विरुद्ध है उनके नाम नहीं होने चाहिए. This is what we are doing, I'm honestly saying. The second method is, I think, your computer is your good friend. If you put your whole material in the Trinity itself, or the machines of software of the plagiarism to check plagiarism, I think it gives you full details. The red zones, the yellow zones, the orange zones. Kejriwal साहब के सारे zones नजर आते हैं. And you can change certain word in the zone becomes completely green. That's the technique.
Right.
एक बार पढ़ेंगे, दूसरी बार पढ़ेंगे. मेन चीज जो प्लेगरिज्म का है वो ये है कि कहीं ऐसा ना हो कि आपने नकल कर करके ही भरा. ये भी फैक्ट है दैट आप बिना नकल किए हुए या बिना किसी को देखे हुए लिख नहीं सकते. इट कांट हैपन. यू कांट राइट ए थीसिस व्हिच द भगवान कृष्ण हैज डन इन केस ऑफ गीता. इट कांट बी ऑन योर लिप्स. यू विल हैव टू टेक माय बुक, take some other's book, take some material and choose out of that and to make it. But what is important is you should at least acknowledge those authors, those persons, may not be one time, maybe 10 times. And you should not feel about it. आप देखिए बाहर के रिसर्च देखिए, you'll find एक पेज में कम से कम there must be 50 footnotes. आधा पेज footnote का होता है, आधा ही पेज बेटा कंटेंट का होता है. लेकिन हमारा यहाँ उल्टा, हम कहते नहीं फुटनोट होना ही नहीं चाहिए. हमारे यहाँ हमारे यहाँ फुटनोट होना नहीं चाहिए. मैं आपको एक और चीज बता दूं. This I'm sharing something, though it's a personal. I got a thesis recently, say about 8-9 months back. The thesis was from a good friend of mine. Naturally, it happens that he thought it will be a bit quicker in evaluating. The moment I opened the thesis I saw it was a wonderful thesis. The topic was good, but it was from first page to last page, there was no footnote. I thought that must be something novel method of doing it. So I kept the thesis for 10-15 days. A telephone came कि सर कहाँ पहुंचे. मैंने कहा कहाँ पहुंचना है जी, उसमें तो है ही नहीं फुटनोट. आप जवाब सुन के हैरान हो जाएंगे. दूसरे साइड में कोई एक मोहतरमा थी, कह रहे सर मैंने तो आपको इसीलिए भेजा था. मैंने कहा अच्छा कोई बात नहीं. मैंने कहा नहीं, ये सर की थीसिस है ना, उससे बात करा दो, सीनियर प्रोफेसर. सर केम आफ्टर 2-3 डेज, वो समझ गया. तो मैंने कहा सर ये क्या चीज है, इसमें तो कहीं फुटनोट ही नहीं. चलो एंड नोट हो, चलो सारे थीसिस के बाद भी लिखा हो, आई कैन मेक इट, कोई गलती हो. खिला रहे साहब क्या बात कर रहे हैं, आजकल तो ऐसा ही होता है. मैंने कहा साहब मैं भी बूढ़ा हो गया, ऐसा तो नहीं होता है. कह रहे लेक्सस नेक्सस की किताब मेरे पास पढ़ी है, उसमें ऐसे ही है. मैंने कहा वो भी जला दो और इस थीसिस को भी जला दो. मैंने कहा आई कैन डू दिस, एकेडमिक डिसऑनेस्टी इज नॉट पॉसिबल. मैंने कहा आप मेरे दोस्त हैं, आई कैन डू वन थिंग, इधर आई रिटर्न इट, बट दैट रिटर्निंग विल बी. हेलो.
Yes, sir. Yes, sir. Yes, sir.
मैंने कहा either I will return it, but that returning will be not good for the student, or I will say it that it may be rewritten. तो उसने कहा सर आप देख लीजिए. Then I thought that it is better to remain silent so that they will say that the examiner has not agreed or has sent the thesis. They may send it to anybody from whom they can do all that whatever they want to do. ऐसे भी लोग हैं, ऐसा भी काम होता है, होना नहीं चाहिए. एकेडमिक्स में ऑनेस्टी होनी चाहिए. इफ यू डू ऑनेस्टली योर वर्क, आप देखिए प्लेगरिज्म पहले से ही कम होगा. एंड सम लिमिट ऑफ प्लेगरिज्म इज परमिटेड. आई थिंक 21 इज परमिटेड और 18 इज परमिटेड. कुछ तो परमिटेड है. कुछ हम थोड़ा ध्यान देंगे वो तो परमिट हो जाएगा. कुछ तो कंप्यूटर मदद करेगा दूर करने. इट्स नॉट अ बिग थिंग.
Thank you, sir. Now we are going to take the last question of our session, and it's from Avinash Goswami. And sir, he is a research scholar in our School of Law. And sir, his question is what is the significance of literature review while formulating a hypothesis?
Sir, see, literature review is a torch in darkness. Unless you have a torch, you can't walk in darkness. It's a better way of leading your path. Once you actually review the literature, you are actually rejecting the bulk which you need not to go, and you are actually selecting a very good area where you only want to do research. That means you are actually chaff and grain hota hai na. You are actually getting the grain out of the chaff. The chaff remains there, the dirt remains there, the grain comes to you. And on that basis of the grain, you proceed to your research and you reach to the nectar of the research. If you do not do the review, then perhaps my book will be actually placed in your research somewhere because you are not reviewed it. Review से सारी वो गंदगी दूर हो जाती है जो गलती से कहीं आप research में डाल. So in order to become purified, in order to make it very simple or as transparent as anything, review of literature is must. And by review of literature, you are saving your time of writing your thesis.
Thank you, sir. So now I request our esteemed Dean, sir, to put forward concluding remarks. Please, sir.
Thank you, Dr. Rohin. Professor Raina, sir, in his very imitable style, in a very easy to understand, in a very friendly manner, we all, especially faculty, can learn how to teach with very good illustrations. Like he was saying on literature review, that it is like a torch and through which we can find a way, or segregating chaff and grain. So in a very nice way, this topic is very dry, and most of the time I find students, they are running from this legal research topic. Faculty also find it very uninteresting. But he had made it so simple in a very lucid way. He touched all complicated issues, and I am sure after this we will get more interest in literature review and research particularly. But sir, I have one observation that many times we get to learn from a professor of repute like you, from Professor Ben Bakshi, many people we interact. We get a lot of charge, but after a few days again we are back to same. we, we just, like today we are thinking we'll do empirical research, we'll read good journals, we'll do something. But after a few months we find we are not moved an inch. So I would request some solution to that, how to move substantially, how to progress in the research area.
Thank you very much, sir.
Thank you very much, sir.
May I put a small suggestion, sir?
Yes, sir. Please, sir.
I do not know, but it should not look like that I'm seeking something. I think that those scholars who are doing PhD, I think if your university agrees to it,
Yes,
there is always a possibility of a co-supervisor type or a co-consultant type.
yes, sir.
So, for example, Malhotra Saab can be a co-consultant or a co-supervisor for 2 researchers or 3 researchers, so that in their area the research can be done properly. Whosoever may be the guide, he will be the principal supervisor, and the co-supervisor can be somebody else who has an authority or a meaningful area in that. Many universities are doing it. I'm somewhere associated with one of the universities.
Sir, we do have the system. Professor Furqan Ali is co-guide in one of the thesis.
हाँ, मैं वैसे ही कह रहा हूँ कि कभी-कभी रिसर्च में आप जो उस एरिया का हो, एक को सुपरवाइजर लगा दीजिए. I think there's no question of excessive money in any case.
Yes,
but the research आपका बढ़िया हो जाएगा. Scholar का research बढ़िया.
Sure, sir.
Thank you very much. So nice of you, sir.
We are much obliged, sir, for your valuable suggestions and precious time. Thank you very much. Thank you, Dr. Rohin Kaul, for organizing such a wonderful webinar.
Thank you, sir.
And thank you,
Okay.
participants.
Thank you, sir.
Thank you, Malhotra, sir.
Thank you, Mr. Pradeep. Thank you, Mr. Rana.
Thank
Thank you, Professor Raina.
Thank you, sir.
Thank you very much, sir.